And I'm joined this week by Senior Fellow at the American Enterprise Institute, Christopher J. Scalia. And Christopher, thanks for being here with us this week.
You're welcome. Thanks for having me.
You've done a piece in this week's issue of the magazine looking at President Trump's flag-burning executive order. And obviously most conservatives don't like the practice of burning the flag, but there has long been a divide among conservatives over whether it constitutes protected speech or not. Could you walk us through a little bit about the sort of the history of that?
Absolutely. The divide is really most noticeable in 1989, the Supreme Court decision, Texas v. Johnson, a 5-4 decision, and it was a really interesting split. The majority included some well-known progressive justices, Harry Blackmun, Thurgood Marshall, William Brennan, but then also two Reagan appointees, Anthony Kennedy and my father, Antonin Scalia. And then the minority opinion, the dissent, was written by William Rehnquist, the Chief Justice whom Reagan appointed to that position, Reagan's first Supreme Court pick and the first woman on the court, Sandra Day O'Connor, and then Byron White, who was a moderate, and John Paul Stevens, who was liberal. So it was a really surprising combination of votes. I think people would have assumed that the conservatives would have been against flag burning, but that just all the liberals would have been, supported as a free speech right. But that's not what happened. But in any event, the majority ruled that Gregory Johnson, a Texas man who burned a United States flag outside the Republican convention in Dallas in 1984. Was protected constitutionally by the First Amendment. Flag burning, contrary to a Texas law which fined him and put him in prison, flag burning was protected by the speech clause of the Constitution. My father subsequently explained that flag burning to him was constitutional as much as he despised the act, because as the phrase would have been understood by the people who ratified the Constitution, the freedom of speech included not only direct speech, spoken words, but also symbol and symbolic acts. So Morse code, semaphore, and in this case, burning a flag would have been protected. Now, fast forward to 2016, after Trump won that first presidential election, beating Hillary Clinton, he tweeted, it was then called Twitter, that he thought flag burning, people who burn flags should be arrested and fined. And so the executive order he issued on August 25th is kind of a fulfillment of that very early expression, that desire he had to punish people for burning the flag. In the press conference in which he discussed that executive order, he said that this executive order would ensure that flag burners are fined and get a year in jail. The actual executive order is much more cautious and circumspect. What the executive order does is say people who burn American flags, will be considered by the Justice Department prosecuted for related crimes, for example, trespassing or things like that. And it seems like the Justice Department is going to litigate certain cases to see whether there's any wiggle room for more exceptions under the First Amendment, and particularly for what's known as fighting words. And those are examples of expressions that are just really meant to incite violence. Texas v. Johnson basically said that when Gregory Johnson burned an American flag outside the Republican National Convention, those weren't fighting words. So right. I don't know what instances of flag burning would constitute fighting words. So I think even they're on shaky legal grounds. But the executive order itself is not the flagrant violation of Supreme Court precedent and the First Amendment that President Trump would have intimated.
So Trump has himself at various points argued that flag burning might cause riots, or
yes.
It might get people to fight each other and beat each other up.
More than that, he's in the Oval Office. He said that we're seeing that happen. He said that the Supreme Court protected flag burning under their First Amendment. He said, and that was based on speech. But I think there's a better argument.
Through a very sad court, I guess it was a 5-4 decision. They called it freedom of speech. But there's another reason, which is perhaps much more important. It's called death.
And he went on to say that we're seeing tons of flag burning and it leads to incredible violence and many riots. I don't know what examples he's talking about of incredible violence caused by flag burning. I think we have seen instances of flag burning by the Hamas supporters, for example.
Sure.
But those acts have not caused the riots. The riots were already going on, and they have not led to great instances of violence either.
So after Texas versus Johnson, Congress sort of acted,
Yes.
but they didn't pass or try to advance a constitutional amendment, as many people thought would be required. Tried
Yes.
to do it legislatively, and most states had banned flag burning prior to Texas v. Johnson. Now Congress tried to do it. The Bush White House, the George H.W. Bush White House, they were eager to sign it, but they were pretty skeptical that this was going
Yeah.
to pass Supreme Court muster, and ultimately
It did not. Yeah, that was 1990, and again, another flag burning case, and the same 5-4 breakdown ruled that the federal law, which was slightly different than the Texas law, was unconstitutional. And you're right, 48 states had flag burning cases or flag burning laws on the books. People who think that, like President Trump and Vice President Vance, who think that flag burning is not protected by the First Amendment, often say that, you know, for as long as the Republic has existed, flag burning was forbidden. And that's really not true. First, flag burning laws that were about political expression didn't, or flag desecration laws that had to do with flag burning didn't come about until World War I. There were flag desecration laws that made it illegal to use images of the flag for advertising purposes. But President Trump likes using the American flag for advertising. He has the American flag on his shoes, for example. So I'm not sure that they're going to want to point to those laws as precedent for what they're up to here.
Does the difference in the composition of the Supreme Court matter in this? I mean, obviously, it is a majority conservative Supreme Court, but even Clarence Thomas wasn't on the Supreme Court yet the first time this was ruled on, or the most recent time it was ruled on.
When my father was on the court, when he was first on the court, he was really the only originalist. That has changed, and in large part, it's changed because of President Trump and the excellent appointments he made during his first term. The majority is originalist. So if all of those originalists take my father's view of the First Amendment and how flag burning applies to it, then I don't think this would have a shot at the Supreme Court. But originalists don't always disagree, and there is room for a disagreement. Even here, to give one example, one of the conservatives in the late 80s who disagreed with that flag burning case was Robert Bork. Robert Bork had been nominated by Ronald Reagan to serve on the court. He was a very influential originalist who, of course, didn't make it to the Supreme Court.
Right.
But he thought that flag burning was not protected under the First Amendment. He disagreed with my father on that. So I don't know for sure. It's hard to say definitively, but my hunch is that if it did come to the Supreme Court again in similar circumstances, the Texas v. Johnson would not be overturned.
Thank you, Chris.
Thanks very much, Jim.
If you're following us on YouTube, you can read Christopher's full article in our Washington Examiner magazine.